Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now that the formalities are over, let's talk about what we should talk about this evening. Now, for those of you who maybe are joining us for the first time or it's been a while, like I said, my name is Scott Reich. I am a practicing criminal defense attorney. Been doing it for 30 years now. I guess January, which will be rapidly approaching upon us, will be year 31. Man, it goes by so fast. So we started this channel several years ago, and it was all about the time of the Chris Watts trial. And it was just really out of frustration that there were lots of people talking about the Chris Watts case. They didn't know what the heck they were talking about. They didn't know the difference between an arraignment and a preliminary hearing. And somebody said, a friend of mine said, you could do that. I'm like, nobody wants to listen to me. And well, you know, for some cases, nobody wants to listen to me. But we do try to provide straightforward, fact-driven legal analysis on various cases and just tell you the way it is. All right. Give you kind of the inside baseball type of situation where we talk about what's going on both the prosecution side and the defense side. Having been on both sides, obviously much longer on the defense side, I can tell you, and you know, we've called it. Even I just always think back to the Chris Watts case. There was a coming time. I think they were set for an arraignment, but they added it on. And I said there could be a plea agreement, and sure enough, he pled guilty straight up to avoid the death penalty. Called it right. We were talking about the Kohberger case. I said after the motions hearing, after the defense lost everything, that they're probably going hat in hand, doing a little bit of groveling to the prosecutors to try and get the death penalty taken off the table. And sure enough, yep, they did. And, you know, I'd like to think that we're able to predict. I think, you know, through independent analysis, we're right 98.6% of the time. So that's pretty good track record, to say the least. And so, yeah, you know, we talk about the cases, and sometimes people agree with me, sometimes they don't. But that's okay. We can agree to disagree on particular cases. I mean, I'll tell you, the Karen Reed case. You try that case anywhere else in the country, and that would have been about a 2-hour guilty verdict in any jurisdiction. And you know, the prosecutor, the special prosecutor in that case, you know, that guy put on a masterclass. But the jury had already made up their mind before they even started. So I don't know. I mean, I know people don't like that particular analysis of it, but that's just my opinion. You know, and we'll see. You know, the civil suit will come out in the Karen Reed matter, and you know, we'll go from there. And then just the other day, we were talking about the Mark Sanchez case. For those who don't know, Mark Sanchez is a former NFL player turned broadcaster. He was in Indianapolis, supposed to call the game. But then, you know, what happened? He gets into a little altercation over the weekend with the guy that was responsible for picking up the grease from the kitchen from the hotel that they were staying in. And apparently, allegedly, Mark Sanchez was intoxicated and somehow got into some sort of verbal altercation that turned physical with a 69-year-old guy by the name of Perry Toll, and beats the crap out of the guy. And the guy, the 69-year-old guy, wasn't sure why this guy was climbing into the cab of his truck, why he is threatening him, why is he assaulting him, and he has a knife, and he stabs Sanchez a couple of times, and Sanchez gets charged with at least one felony. We'll see. But I told you, well, better get the checkbook ready, Mr. Sanchez. And sure enough, what happened? The guy, the victim, is filed a civil lawsuit, not only against Mark Sanchez, but against Fox Corporation. And obviously they're requesting damages. The individual who did the stabbing was acting in self-defense. says that he has suffered severe permanent disfigurement, loss of function, and other physical injuries, emotional distress, and other damages as a result of Sanchez's action. And knowing that Sanchez probably has a few bucks, but doesn't have as many bucks as they would like to get, they're going to sue his employer, saying that the Fox Corporation knew or should have known about Sanchez's unfitness as an employee, propensity for drinking and harmful conduct, and failing to supervise him in a capacity as an employee. And the suit also accused Fox Corporation of negligent hiring. Or, Fox is going to say, yes, he was employed. Yes, he was there for work. But no point did drinking and assaulting a driver have anything to do with our terms of employment with Mr. Sanchez. And he wasn't acting within the scope and authority of his employment, and therefore they should be dismissed from the lawsuit. But of course, they'll probably settle for something. Anyway, the plaintiff in that case is seeking compensatory damages in an amount to be determined at trial, punitive damages to be determined at trial, costs and expenses of this action, including attorney's fees, and any other relief that the court deems appropriate. Now, of course, Sanchez was initially charged with battery resulting in injury, public intoxication, unlawful entry of a motor vehicle, and that's for when he went into the truck of Mr. Toll in this alley on Saturday morning. And the prosecutors intend to upgrade the charges once they become aware of the victim's total medical issues. What can you do? Sanchez is out on a $300 bond. I mean, you just, I don't know. I mean, and this happened late at night. Mr. Sanchez, apparently it's quite clear. There's video out there that Mr. Sanchez was partaking in a few adult beverages, probably clouded his judgment a little bit, that somehow he thought he was going to become the parking police at the hotel. Like, why? Let it go. It's not your business. And now your whole world is turned upside down because you wanted to play parking police and tell this guy he can't park there. And next thing you know, you're getting stabbed. You're in the hospital. You got felony charges. If he hasn't been so already, I think he's on leave. He's going to get more than likely terminated because of this, because he's probably got a clause in his contract that says you cannot embarrass anyone associated with Fox. And on top of that, Fox got sued or is going to get sued and get service of process and whatever. Now, I don't know all the details, obviously, but we've seen some of it where Sanchez was there, and I just don't understand why somebody would let it go. But that's what happens when, people drink. Their judgment, their good judgment, it kind of goes away sometimes, and that's the way it is. That's just the way it is sometimes. But hey, what can you do, right? I've always said it, and I'll say it again. The three things that keep criminal defense attorneys employed: first, sex, drugs, and alcohol. You take away those three things, man, there's not going to be any work, right? And when I say sex, I'm talking about, the opposite sex. Drugs, obviously, people do stupid things when they're under the influence. They commit crime to get the drugs. And then obviously alcohol inhibits people's good judgment that they should be, bringing to the situation, but it usually goes out the window. And so that's what would be it. And of course, you always have, well, I was drunk. I didn't know what I was doing. And, therefore, that's, I should be not guilty. I don't remember anything. And I always tell people, if being drunk or on drugs was a defense, no one would ever get charged with any crimes, because most people commit the crimes when they're drunk or on drugs, or they're in the heat of the passion because of a other person, the opposite sex or something along those lines. And that's just the way it is. So anyway, this is our Tuesday Night Live show. Obviously, we didn't do a show last week because of those if you watch regularly, had to go to Italy. My son was getting married in Como, Italy. I highly recommend anybody, if you want to go to Italy, go to Como. It's very nice. Little pricey, not going to lie about that, but it was a special occasion, so it was worth it, obviously. And flights are a little expensive to get there too these days. I'm not going to lie about that one either. And but it was great. My son got married, made it all official, all that good stuff. And it was a lovely, lovely time. And kind of fall weather rolling in. They had a bunch of torrential rains the week before, but it was perfect. We had wonderful weather, just beautiful. My son looked great. His wife looked amazing in her wedding dress. Family, friends, it was a good time. So we didn't do that, but here we are back. And now we're going to talk about whatever you would like to talk about. We will put up the call-in number. All right. There's one person out there that's always one of these pro burgers. And I always say, hey, if you think Bryan Kohberger is innocent, you get first priority. Okay. We had that in a while. But so I think I saw them leaving a comment saying, oh, when are you going to have a show, Scott? Well, we're doing it tonight just for you. We'll also take your comments as well. Let's ask this. Sally wants to know, Scott, is it possible that Luigi could get off in New York because of the false arrest in Pennsylvania because they didn't have a warrant in Pennsylvania, or is that moot? Well, you have to remember, Luigi Mangione, obviously accused of assassinating the United Healthcare CEO, Mr. Thompson, shooting him in the back outside of a hotel. It's an investors conference that they're having there. Luigi Mangione, flees, ultimately is arrested in Pennsylvania. Okay. It was a warrantless arrest. I mean, they knew generally who they were looking for at that point. I can't remember off the top of my head if there was already an arrest warrant, but if not, he was certainly a suspect, and somebody identified him at the McDonald's and said, hey, that's Luigi Mangione. That's the guy we're looking for. So the cops go up to him, identify him. They find various things, forms of other IDs on his person. I can't remember. I don't think they found the gun as well. I do believe, just a bunch of stuff, right? So yes, it was a warrantless arrest, but then it goes in front of a judge. Judge looks at it and says, yes, there was probable cause that this guy was a suspect. Turns out he was a suspect. And then the question is, there was a motion to suppress the arrest, search of Mr. Luigi Mangione in Pennsylvania. And that would only go to suppression of the items found in his backpack as it related to that particular case. But of course, if a judge were to find that it was an illegal arrest and illegal seizure of those items, then one could argue in New York and the federal court as well, where he's also charged, that, you should follow this judge. They got it right. But as we talked about today, the feds aren't letting Mr. Mangione go back to court in Pennsylvania, at least not until the case is over. But the question that becomes is like, okay, I mean, the state's probably going to have to dismiss in Pennsylvania unless Mangione's going to agree to toll or something like speedy trial. But why would he do that? Right. We've got the issues of the motions out there. Those issues are going to be litigated in both the state case in New York as well as the federal case as well. The Pennsylvania, let's face it, Pennsylvania is the least of Luigi Mangione's concerns. False information, possession of forged instruments because of the fake IDs, the gun charge as well. Clearly, he's got murder charges in state court and murder charges and terrorism charges in federal court. So he's got some bigger issues there. And the feds have said that they want to go death on Luigi Mangione. All right. But it wasn't a false arrest, Sally. Clearly he was arrested. The question is whether there was probable cause. I think a judge who's already looked at it and said, yes, there was probable cause, to arrest him. Now, at the motions hearings, when they get to that, they'll deal with that issue. But that's going to be litigated 3 times over: Pennsylvania, state court, federal court. The witnesses are only going to testify. The only one that really matters, obviously, is the New York stuff. Pennsylvania, it's just not a big deal. Frankly, if they dismiss those charges and they never worried about them ever again, it's not going to be any, problems for Luigi Mangione. He's not going to care and say, no, I demand my day in court. I want to have that case tried. They're not going to do that. He's got to worry about the federal stuff, and all those issues are going to be litigated ad nauseum in both the state and the federal motions practice that'll be forthcoming. And like I said, the biggest issue, listen, the state court judge in the Luigi Mangione in New York already threw out the terrorism charge, which, basically was the life without the possibility of parole stuff. He's already won in that regard, because the judge didn't think that it fit under the terrorism statute. Okay, so what? That's what the prosecutors are saying. We'll still get him in murder. We believe, the prosecution believes that they have a pretty strong case in state court that he was the shooter. Used a weapon to do it. His little manifesto, the bullets, delay, deny, and something else on the bullets, right? So, that's where that is. And then the feds, same type of thing. The terrorism charge that under the federal law, trying to say that he was trying to influence, the public discourse as it related to Luigi Mangione shooting the United Healthcare CEO. So, and the feds, they're going to be trying to use the death penalty as a tool. And I've always said that, even as a defense attorney, that the greatest thing that having the death penalty on the table for, because it shouldn't be used on every case, in my humble opinion, but there are cases that are worthy of that, in my opinion. I'm not sure the Luigi Mangione case necessarily would be, but I think the prosecution can certainly make a good argument that, hey, murder is murder. He plotted. He meant to terrorize people. This was for a bigger political issue, and we can't have people going around assassinating people because they disagree with their opinions or their employment choices. That's just not right. So, it could go either way. Now, do I really think a New York jury is going to give the death penalty? I don't care if it's a federal jury or state jury. They don't have the death penalty on the state side, but in the federal side, do you really think the feds are going to give this guy that comes from a well-to-do family, pretty smart, well-educated, gets carried away with his political rhetoric and thinks he needs to go kill somebody? Yeah, I think that's kind of a long shot that's going to happen, but stranger things have happened indeed, but I don't think that's going to happen there at all. But I don't, it'll be litigated as it relates to the search and, the manifesto. There's already been some motion practice in the state court in New York, but the reality of it is, given the circumstances, going to be tough for that to get thrown out based upon what I know at this point. And clearly, if there was something that was really good fact for the defense, we probably would have heard from it by now in the motions practice. I remember reading the motions in Pennsylvania when they were filed. There wasn't anything particularly that offended me, so to speak. And if I was looking at it from the sense of a judge, I'm like, okay, we'll go through the motions hearing, but probable cause, certainly reasonable suspicion to go up to him, develops into probable cause after, gives some vague answers, doesn't have the right ID, things of that nature. Probable cause to arrest, then they arrest him, search incident to arrest, they go through his bag. Oh, look at that, manifesto, everything like that. More than likely not going to get suppressed in any of those jurisdictions. So we'll see from there. Anyway, so if you want to call in, and like I said, all those pro-burgers out there that still believe that he's innocent, you get priority. 752 228-TALK, 725-228-8255. And we'll have a conversation. Only one rule is you have to talk on your phone, turn your computer down, because there is a bit of a delay, even if it's a couple of seconds. Makes for a very weird conversation indeed. Let's take a look if there's any other. Carlos, are we ever going to see the Kohberger arrest video? I don't believe, I certainly haven't seen it yet on anything that's come out. And we've been checking, all the police departments, stuff that's been made available. Frankly, there hasn't been anything particularly earth-shattering that's come out as it relates to that information. And frankly, this is what I think is always kind of funny. All of the discovery in the Kohberger case, okay? All the discovery in the Kohberger case, terabit upon terabyte of information, right? Videos, surveillance, leads, tips, blah, 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 everything out there, right? Everybody made such a big deal about all the discovery, the size of the discovery, so voluminous, the defense will never get through it all. Most of it is completely superfluous. Most of it is completely irrelevant. And most cases that people kind of lose sight of when it comes to a criminal case is that most of the stuff really is irrelevant. The only thing that matters and the only thing that's relevant, right? Does it go to prove or disprove a element of the offense charged? And if it doesn't go to the element, guess what? It doesn't really matter, right? That's why people always get, like twisted around the eye. Well, what was the motive? Doesn't matter. Don't need to prove motive. They just have to prove identity, right? They have to prove loved. I've talked about this before. Let me see if I have my little handy dandy. Let's see if I can write this big enough. Maybe I'll see. The only thing that matters in any criminal case, and this is all you need to remember, do this in every single case. This thing isn't hooked up, is it, Frank?
No.
Loved. There it is. Location, the offense, the victim, identification, date, and time, right? When you read the allegations, on or about this date, right? So you have to have date and time. Perfect, right? Identification, who's going to come into court and ID the defendant as the person that committed the crime, right? Because they have to prove that it was the defendant, not somebody that looked like the defendant, not somebody that looked like him using his identity, but it was in fact the defendant. And that's why obviously sometimes it makes murder cases difficult, because the person that could do the identification is deceased, obviously. So you have to come up with other evidence to say that it was the defendant that did it. Obviously, you got to have a victim, right? Some cases, like drug cases, there is no victim, but let's, assume we're talking about a murder case. The location, let's jump up there at the top, right? That it was in the state or the county, obviously establishing jurisdiction, venue in that particular case. They always ask, it sounds weird in court. You never see it on TV, but they always ask, was that then and is it now in the city and county of Denver, state of Colorado? Yes, it is. Why do they ask that silly question? They said the date, right? They always ask of the police officer on the stand because they got to prove that it was in the appropriate jurisdiction. That's a jurisdiction issue, right? The offense, they got to prove the elements. So on the offense, let's say murder, that it was the defendant. After deliberation, caused the death of another, right? So that's why they got to bring in, the elements of the offense, cause of the defense of the victim, right? And they give a date and time because they got to put everybody on notice. That is all you have to prove. And most of the stuff that, they turn over in discovery is completely irrelevant. And it's sometimes one of the most frustrating things that you have to deal with is, particularly on the defense side, is you say, hey, listen, this is what they have to prove. Like, we don't dispute that the crime took place in here, right? We know who the victim is. Identification, we're saying it wasn't us, or if it was us, that we were justified in doing it, right? And the date and time. So, that goes to, do you have an alibi somewhere? Put you on notice. So you can say, it wasn't me, I wasn't there, right? I had an alibi. Told you this, I've never had an alibi work in trial ever, because if you had a solid alibi, let's face it, you wouldn't be charged there, okay? And if it's somebody that shows up as their witness and says, oh, my girlfriend says that she was with me all night. Really? In today's world, really? Show me your phone, right? So that's where that comes from. But some of the stuff is so superfluous. It doesn't matter. Even in the Bryan Kohberger case, they had his car, established identification. And he knew it was his identification, right? Because we knew Kohberger, he ultimately pled guilty. He's like, it's a confession, admission that he did it. We knew the location. We knew the offense. We had 4 deceased bodies. We had all the victims, right? It was the identification that they were trying to prove. Well, it was somewhat circumstantial, but remember, circumstantial evidence is viewed under the law the same as direct evidence. And there's a jury instruction that juries usually get. Circumstantial evidence is considered, has the same strength under the law. And people are like, wow, it's a circumstantial case. So what? Let me give you an example, right? If I look out the window right before I go to bed and I see that it's snowing, I see the snow. I wake up in the morning and there's snow on the ground, but I saw it. That's direct evidence. I could testify it was snowing, which would make sense as to why there was snow on the ground in the morning. Circumstantial evidence. I look out my window at night. I see that it is dark, but it is not snowing. In fact, there's no sign of precipitation whatsoever. I go to sleep, not a concern in the world. I wake up in the morning and I realize, I look out the window, that it has snow on the ground. Now, I didn't see it snow, but one could reasonably infer that if there's snow on the ground, even if I didn't see it, guess what? That it snowed. That's circumstantial evidence. So when people say it's a circumstantial evidence case, doesn't mean anything. Circumstantial evidence cases they happen all the time. Most murder cases, unless there's a confession or there's a video or an eyewitness, guess what? It's a circumstantial case. So some people get all worked up about that stuff, and it just really isn't relevant, right? Like, I have had cases where they're like, yeah, but we got to look at the metadata here on this particular photograph and blah, blah, this is really important. And you're like, you look at your client like, no, tell me why you think that's important. And why does that change the fact that if we go to our little loved, that, you had relations with an 11-year-old, right? The metadata doesn't want to do that. Do we want to show a picture of you having relations? I don't think we want to go there, right? Those types of circumstances. So most cases, really, when you boil them down, they're quite simple. They really are. Think about it. What's a homicide? It's a misdemeanor assault gone bad. That's really what it is. But we make such a big deal about it. And yes, the reason why we make such a big deal about it is because someone's liberty is at stake, right? But think about it. Okay, they're going to get life without the possibility of parole. There's lots of offenses where you can get life without the possibility of parole. You could be a career criminal. You could go to prison forever. You could have lots of offenses and get stacked up one after another, where you could wind up spending essentially your life in prison. But most homicide cases are pretty straightforward. And heck, we had one we just did. Unfortunately, it didn't go our way. But once again, pro tip, just like I told you afterwards, if you're going to shoot somebody, one, don't do it on camera. Another pro tip, probably don't want to do it. Shoot somebody in the back makes self-defense really, really difficult. All right. That trial had the prosecution had their witnesses lined up. They could have done that trial in one day. It was a simple case. It was a simple case, but it still wound up going 4 days. And it always surprises me when you see these. I mean, I see these trials that take place. They take months. Seriously, the Karen Reed case, just by way of example, what that case, 4 to 5 weeks that case took. 4 to 5 weeks. Are you kidding me? Any jurisdiction that I've ever practiced in, that would literally be like a 7-day trial. So 7 days, Monday through Friday, and then, the next following week, another 2 days. That's it. I just don't understand how these people drag these cases out in these trials so long. Most cases are pretty straightforward. They really, really are. And although I have said, as a defense attorney, it's my job to make the simple complex and to make the complex quite simple, right? One of my favorite things when I get to do is get up and say, ladies and gentlemen, this is a simple case. It's a simple case about my client being wrongfully accused of a crime that he did not commit. And then I start going into the facts and explaining why this injustice is taking place. And it is the jury's responsibility to correct this injustice. But the reality of it is most cases are simple. Okay. And all I got to prove is the loved location, the offense, the victim, ID, and date and time. That's it. That's the only thing that's required. Motive is not required. And all the discovery that you hear about being turned over, like in the Kohberger case, 99% of that's never coming in. Never going to make it into evidence. Will be reviewed by somebody, but at the end of the day, not relevant. And so I think, the defense was very disingenuous when they said they needed a continuance again, and it was obviously going to be denied or was denied. And that's a good thing. And obviously it forced Kohberger to make a decision, as well as the prosecution decide to give him the 4 consecutive life sentences without the possibility of parole, versus the whole, situation of whether they should, go forward with the death penalty. Certainly a case that would have warranted the death penalty, no doubt. How many murders do you have to commit before you kind of realize, hey, maybe you're just not really meant to be here in society when you start killing innocent people. So yeah, what can you do? All right, let's see here. Sally, maybe the prosecutor will get on the stand and admit misconduct like in Alec Baldwin's trial, and then it'll be double jeopardy and he gets off. Maybe, Sally. There's always that possibility. But let's see here. See, Carlos, thanks for this comprehensive answer. I did not know about Loved. I have followed you for more than a year. I love your show. Love how clear you are when you explain the cases and also the jokes. So I appreciate that. So yeah, well, thanks, Carlos. But and like I said, that Loved, think about it. If there's a case that you're following, and you really want to get wrapped around the axles, wrapped around the axle of case, don't just Loved. All right, where's the location of the offense, right? Just pick the Kohberger case, right? We got the home off campus, the offense, murder, burglary. What evidence is there to prove that the murder took place, right? And then the victims, obviously, they got to identify the victims, the identification. That's usually the key thing about any given case. Did the defendant do it? Did the defendant, if he did do it, was he acting justifiably under the law? Most commonly, like a situation of self-defense, right? If it's murder, you have a couple of defenses. It wasn't me because I wasn't there. If I was there, I didn't do it. I didn't pull the trigger. But if I was there and maybe I did pull the trigger, I acted in self-defense. And of course, the good fallback is always the dead guy deserved killing. Now, I say that tongue in cheek, so don't get all offended. But it's, sometimes that's the defense you have, is that the dead guy deserved killing. Try to besmirch the dead guy as much as you can because, hey, our client clearly didn't like the deceased guy. Maybe the jury won't like him either and say, well, the world's a baby, just a little better off. Now, obviously that, I say that tongue in cheek, ladies and gentlemen, because we're talking about criminal defense stuff. We're talking about sometimes some very dark stuff. We've talked about this before as well. If you can't joke about some of these cases sometimes, amongst your colleagues and peers, it can be a heavy burden. And, I've lost lots of attorneys that I've known. I wouldn't say they were close friends, but certainly acquaintances that you know in the profession. You see them in court. You talk about things when you see, in court. You talk about cases and things like that. That have taken their own lives because of the stress that comes with this job, and you got to be able to turn it off. You really do. But sometimes you say things kind of tongue in cheek, and like I said, that's my personality. I'm a little bit sarcastic, which I think is a great way to. We were just talking about it. We have a trial coming up, and the other side wants us to step to some exhibits. Every time we ask for something, oh, sorry, we can't do that. So when they ask to step, we're gonna, sit on it till tomorrow. Maybe like, oh, sorry, can't do that. And it would probably speed things up, and we knew it. But you got to have your client's consent, to when you do stipulations, and they want to just brush through some stuff that doesn't help their case, but they feel like they got to tell the story and move it through. And we're like, yeah, no. So those weren't drugs, right? So no, I want you to bring in all the lab techs to say you're a really good lab tech, right? Really? And what you thought were drugs turned out not to be drugs, right? Now we still got other problems to deal with, but dead bodies and things like that. But the reality of it is like, I love that. Like, I would be sarcastic as hell. Let me get this straight. You're really good at your job. You've been doing it a long time. You got a master's degree, tested thousands of stuff. You know exactly what you're doing. And you followed all the procedures and you did everything wonderful and you did everything great. And guess what? What you thought and everybody thought, they tested it, turns out not to be drugs. Isn't that true? Okay. You sure about that though, right? You positive? And then sit down. A little bit of sarcasm there. Always goes a long way. And the jurors get it too. Sometimes they don't like it, but hey, what can you do? You can't please everybody, to say the least. All right. Amy Bulger, unbelievable. I don't know what that's in response to. Judge, unbelievable. Judge Bear was crooked, delay, denied, deposed. That was it. That's a delay, denied, deposed. Sorry, I couldn't remember the last one there. Let's see. You should have used the McDee's drive. You should have used the McDee's drive. Let's see here. I'm looking at some of the comments here on the monitor off screen here. Sally wants to know, Barry Morphew, did he get out and what happens because he moved to 30 minutes from the Mexico border? Is he free? Yes, Barry Morphew got out. In fact, there was that he had posted his bond. And frankly, I was a little surprised that he posted the bond. Because he posted a $3 million bond, which means he had to come up with $300,000 collateral, or as a fee basically to a bail bonds person. We have a whole show. We talked about this a couple of weeks ago. So he's got a $3 million bond. He can either post cash, which he didn't have, and that's originally what the bond was set at, was $3 million. But the judge modified the bond and said you can do cash, property, or surety. And the cash obviously is $3 million. Barry Morphew doesn't have $3 million to lay out. So he went through a bail bonds person. Bail bonds person, just for easy numbers, 10%. $3 million bond, $300,000. You don't get that $300,000 back. That goes to the bail bonds person. That's their fee for taking the risk. But most bail bondsmen want $3 million in collateral. So in case Barry Morphew were to hypothetically hop the border and go to Mexico and try to disappear, the state's going to come and say, we want the $3 million. So where is it? So the bonds person, who's usually, writes the bond through an insurance company, insurance company's going to say, hey, we want to find him just as bad as you do, judge. Right. And so they will delay as much as they can, try to find him, send out bounty hunters to find him. But eventually they're not going to do it. And if they have to pay that bond, guess what they're going to have to do? They're going to have to pay the bond, the insurance company, because they got lots of money, right? They're insurance companies. But then they're going to wait, that's okay, but we want to get reimbursed. So whoever's collateral, I think it was set up on Barry Morphew's deal. I think there was some sort of statement, I think, by his attorneys that they want to thank his friends and family for helping post the collateral on the bond. Okay. Also spent $300,000. That's not going to go to attorney's fees. I mean, and that's one of those weird things, you got to kind of ask yourself, the attorneys are going to say, well, how are we going to get paid now? There's a big case, a lot of time, got to check out all that superfluous stuff that's out there. And, it's going to get expensive, because, David Beller, I don't know, he's probably charging $500-600 an hour, maybe, plus his firm, plus investigators, plus paralegals, you name it. They're probably billing several $1,000s a day. It's going to, next thing you know, $350,000 is going to be eaten up pretty darn quick. And so, he's out. But the attorneys are probably saying, I hope we get paid, because they just wasted $300,000. Should have spent it on the attorneys. And sometimes that's a tough call to make. I get it. Nobody wants to be in custody. Who wants to be in custody? I wouldn't, right? Your kids. But if you have to make a hard decision as to being in custody and getting the best representation you probably could, which means, pay your attorneys and use it for the expert witnesses that you think you're going to need to explain why Barry Morphew was one of the few people in the United States, let alone the state of Colorado, that had access to that tranquilizer referred to as BAM. I think I'd rather have those experts at the end of the day. Hey, Frank, quick interruption. Hey, Frank, I think there may be a delivery by the door. Sorry about that. Excuse that. But we were a little behind schedule. The evening got away from me. And next thing I realized I was still working, and it was 6:00. And so for making Frank stay late on Tuesday nights, I always buy him dinner on Tuesday night live shows. He gets to pick where he wants, and we usually Grubhub it. Uh-oh. But apparently it may have got delivered. I'm getting a message that maybe it got delivered to my home and not the office address, which is not good for Frank. I'm not particularly that hungry, but you never know. Scott, any interesting trials coming up? Well, got a couple of them. I have a lot of murder cases coming up. So yeah, I got a couple of interesting ones, got a couple of cases, some stuff I really can't get into the specifics of it, but we've got couple of homicides coming up, and one's really interesting, kind of a murder for hire type of thing. Can't really get into the whole lot of specifics of that, but that's going to be an interesting one. And, just some other stuff. Unfortunately, I can't really talk about a lot of it while it's pending, although I wish I could, because some of them are really interesting and I could bring you all on as my co-counsel, but I don't want to do anything that's going to jeopardize, obviously, my client or any ethical violations. I certainly don't want to commit any ethical violations like that. So yeah. We do have a couple of good ones. Even Frank and I were talking about a minute ago is, no, I'm sorry, Frank. I'm starving you. I think it got delivered to my home address. I owe you. We'll shut it off at 7 so that you can get home and eat before it's too late. But we've noticed, I think a lot of people are in a little fatigue right now. And when I say that is, I think there were so many kind of big cases going on that a lot of people were just like, you had the Kohberger stuff and it was like, okay, it's building up. And then all of a sudden it was just done. And it seems to be like a little fatigue about that. You had the Karen Reed case. It was building up. And we had all these cases all kind of culminating. We had the case down in Florida as well. All these kind of cases all at the same time. And it was just, we had this plethora of cases and it was great. And now I'm kind of looking around and maybe you guys have some good suggestions, but, is there a particular case out there that's just absolutely super intriguing to you? I mean, there's always crazy cases going on. But is it going to be, you really like the ones where, everybody just, where you just, there's truly a question of fact whether the defendant did it, right? So often times it's not really a whodunit. We know the guy who did it. He confessed. It's on video these days, right? So when you get, cases like the one in Indiana, even, Karen Reed, they kind of spun that one up pretty good. Even Kohberger there for a bit, like, there's enough. Maybe there's just enough for reasonable doubt. Those are intriguing cases, but it just doesn't seem like there's a whole lot of intriguing cases going on right now. And it's not for a lack of looking on our part, I assure you. But if there's a case you think we haven't talked about, please let me know. We'll check into it for sure. Because obviously we want to talk about interesting cases and cases that people want to talk about. And that's the beautiful thing about the court system is there's so much stuff. And although we can find cases quite easily that are, but they're not getting the national attention that, people are saying, oh my gosh, have you heard about this case in, Utah or whatever? Even the case as it relates to the death of Charlie Kirk and that young man. Not really a whodunit, right? Don't see a whole lot of motions issues in the case. The Tyler Robinson matter, the man accused of assassinating Charlie Kirk there in Utah, their intentions are to go death in that particular case, but it's not a whodunit. You know what I'm saying? It's not a whodunit. Maybe some people's going to try to do it, but he basically confessed to his own parents, for goodness sakes. That's usually a pretty good indication. And when your parents are going to have to come testify against you, plus all of the other data these days, what it's going to come down to is, are they going to go death? That's what it goes down to. And usually cases go death because there's overwhelming evidence for the prosecution. And then the defense's goal is to make the death penalty go away. Every death penalty case that we've talked about here, the goal is, can we make death go away? That's their goal. They know they got a very, very slim chance of winning the actual case in chief. Guilty, not guilty. Trying to think, when was the last time I can recall where somebody was actually acquitted of a case where the death penalty was going to be on the table. Even OJ wasn't a death penalty case in that sense. But so that's really what it boils down to, right? Is there's just not a lot of these cases going on. Let's see here. You saw her life was on the line. That was horrible how she was framed. It was nerve-wracking. Sally, I love you. I love you. I do. Like I said, you try that case in any other jurisdiction, 10 out of 10 times it's going to come back guilty. But the jury, they had their mind made up before they even started, in my humble opinion. And people that watch that case, that talk to me about it, they're like, I watched that case, and they're just like, yeah, I just don't get it. Like all the stuff they're trying to say. The second trial, usually the second trial on a mistrial goes much better for the prosecution, and prosecution fixed all their issues. And, clearly the jury had some predisposition, so to speak. They knew about the facts of the case. It had been all over, particularly in Boston, there in the Boston area. But I mean, they didn't even bring in all the stuff about, him being killed inside, the alternate suspect, right? It didn't even come in. And some of the jurors were talking about, well, it's obvious the alternate suspect, they beat him up inside. Well, that didn't come in evidence. Oh, yeah, right. Yeah. It just wasn't him. Yeah. She didn't do it. I mean, I still, congratulations. Hey, I'm a defense guy, always rooting for the defense. But that one, I still just scratch my head. I scratch my head on that one. But that's the way things work out. That's the way the system is supposed to work. It worked perfectly. And so be it. Now, the civil trial, will she be as fortunate? Who knows? Like I said, I'm sure she is just like OJ, gonna, have to take off to Florida to avoid those civil judgments and, look for the real killer in that particular case. I think she's beating her chest. Her attorneys are beating their chest, saying she's going to sue everybody under the sun. Go for it. As long as somebody else is funding your litigation, Miss Reed, go for it. My experience is, I always tell people, do not litigate on principle. Litigation sucks. It's a war of attrition. Who can go the longest without going bankrupt on the civil side? And usually if you do get a judgment, it's not worth the piece of paper it's written on. And so the best thing to do is to try to settle it. But if somebody else is going to pay for your attorneys to go litigate, it's easy to spend other people's money like that. So as long as she's got a defense fund, I'm not sure it's as built up as it had been, but that's for sure. If somebody else is paying for it, litigate all day long. So when you guys start paying your own attorney's fees, that people start getting a little more reasonable. But hey, Karen Reed's worked for them. She sold everything. I think her parents have sold everything. We'll see if the civil defense fund gets funded as well as the criminal defense fund. So, all right, ladies and gentlemen, it's our Tuesday night. Yes, and Amy, Constitution matters. Couldn't agree more. We always say this after every show. The Constitution matters. There you go, right there. Absolutely. And on top of that, if you'd like to go to the link below, get yourself a Constitution Matters t-shirt. Didn't that turn out nice? Yes, it did. Any size you want, we'll get it for you. Be great. Got a couple of them, right? I like this. We're going to work on this, and then we're Where's the other one? Oh, and our lost my keychain here. Anyway. All right. Well, anyway, thanks for joining us, ladies and gentlemen. It was our Tuesday Night Live show. Check out our show today. We put out a show every day, unless, of course, something comes up with court. But we always try to talk about the cases being fact-driven, unbiased, just telling you the way it is. And thanks for watching. We know there's other things you could do. Appreciate you being here. Have a wonderful night. And yes, the Constitution matters. All right, lawyer.